Hello, I'm Dominic Walker, JMW's Inside Man, and I'm with David Smith. David is a partner in our commercial litigation department based in London. David specialises in property litigation, but also dispute resolution, and that's exactly what I want to talk to you about. Hello, David.
Hi.
So the government has put out a call for information in relation to dispute resolution. Now, to the average user of legal services, that might not be of interest, but what it will be interesting is it's in the context of dispute resolution, what we would call as lawyers ADR, alternative dispute resolution, ways of keeping legal complaints out of court. So, I mean, would you just explain a little bit about ADR and perhaps what mediation is to begin with, David?
Yeah, I mean, part of the point here, of course, is we're trying to take the A out of ADR and stop it being alternative. And the general sort of thrust of where the government's going is precisely that, to bring the various ADR mechanisms into the mainstream. Obviously, ADR actually covers a range of stuff, including sort of traditional things like arbitration, where you essentially have a private court, adjudication, where you have a type of it's not court, but it's usually paper-based, and that's used a lot in construction. And famously for tenancy deposit protection claims are all adjudicated. And then the area I'm sort of most known for being involved in is mediation, which is really just a type of negotiated settlement, but sort of brokered by a skilled, highly trained mediator. Who helps the parties find a resolution to their dispute. And the reality is that a great many court cases can be resolved through negotiation. A lot of people think they're going to get their day in court, and of course lawyers are conditioned to sell that to them. But the reality is that very few people walk out of court wholly satisfied with the outcome. It takes a long time. It's not exactly cheap. And the idea of mediation is to accept that either entire disputes or chunks of disputes can be settled by some skilled negotiation beforehand with someone who's actually trained to achieve that. And particularly for certain types of disputes involving families, for example, or companies who might want to continue to do business together, it can often be better to have the slightly more positive feeling of having resolved your dispute between you, rather than gone to the full sort of place of court where things at the end of the day are going to get pretty medieval if we have our way.
And I guess for business people, for individuals who don't necessarily know that there's an alternative to court action, could you just give us an idea a little bit about what the process is in relation to a mediation, please, David?
Yeah, I mean, there are a range of options, but the most common at the moment is the one-day time-limited mediation. So both parties will pair a set of papers, will pair a rough position statement, and then they will get together for a day with a mediator online often at the moment because of all the things that are going on, but ideally in a face-to-face setting, and we'll try and walk it through together. I mean, the key point here is the mediator's not there to take sides. He's not there to tell them who's right or who's wrong. He's there to help them get to a settlement. And usually that's done in a sort of traditional format by a face-to-face meeting where both sides make their case to each other. That's often quite good with businesses, where in fact you might often have quite senior people will come to the mediation who've not had any background in the dispute. And there's been a fair few cases where the senior people have gone, why are we having this argument? And just settled it on the spot. And then normally the parties split up and trade for discussion, and then hopefully come back together at the end to shake hands and get a deal. There are variations on that now in technology, for example, as allowing, for example, people to try and reduce their dispute down to a single one-dimensional money type dispute, and then use online blind bidding systems, sort of like an eBay in effect, to basically exchange cash offers until they get one that crosses over. So there are sort of developments of all of this now, but the essential principle remains the same, that it's about getting two groups or more than two groups together in a space to thrash out a deal between them. And it's about making a deal, really.
Yeah, fascinating. And you mentioned making a deal. And I think a little bit earlier on, you said that the court process can sometimes be slow. So I just want you lead me nicely really on to what I wanted to ask is, what are the advantages of dispute resolution, of mediation?
Speed. You can get, I mean, generally it would be done much earlier in the process. It's often done pre-issue of proceedings or shortly after, so you can get it quite quickly. Flexibility, you can do it anytime you like. There have been plenty of cases where settlements have occurred a day or two before a court hearing, so it's never too late. The flexibility to come up with an arrangement. At the end of the day, in a mediation, you can horse trade stuff, and you can make any deal you like. They're great for boundary disputes, for example, where people might end up horse trading a bit of land at one side of their boundary for a bit of land at the other in order to square them up. Whereas courts inherently are quite inflexible. On a boundary dispute, for example, a court isn't going to horse trade your land for you. It's basically going to say that's where the line is, and we don't care whether you like it or not. And that's the same with a lot of other disputes. So it allows you to have a bit more of a flexible discussion, and then I suppose the idea that people tend to own their dispute. And then one of the potential longer term side effects that's really interesting out of this post Brexit is obviously court judgments in the UK are a little bit harder to enforce at the moment until we thrash out all of our relationships with other countries. But ADR is actually backed by international conventions. So you've got the New York Convention for Arbitration. The Singapore Convention is slowly coming into force around the world for mediation, and that allows for enforcement of mediation settlements without even going to court in a number of countries. So if you're dealing internationally, potentially ADR is a better deal right now.
David, thank you very much for your insight. And of course, if you'd like to speak to David and understand a little bit more about ADR, you can contact him insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.